Thank you.
Okay, calling the order to meeting. Can I have a mover and a seconder? Councillor Maude Chapman and Deputy Mayor Coughlin. That the special meeting of Council of the Township of Springwater of November 6, 2019 come to order at 5:01 p.m. All those in favor? Carried. Okay, turn it over and thank you. Oh, disclosure pecuniary interest, anybody? No? Okay. Thank you. Look forward to your presentation.
Thank you, Mayor Allen, and thank you, Council, for the opportunity to provide this presentation on sign bylaw. We have called it a sign bylaw training session. Before we really get into it, I'll just give you a bit of a timelines in terms of why we are taking this opportunity to speak to this today. So I'm going to bring you back to 2018. In 2018, we adopted a revised sign bylaw 2018-013, also known sign bylaw. And about a month after our adoption of that bylaw, there was a presentation to council regarding an issue with a sign that did not have a permit at that point, a sign permit. Council listened to that presentation. There was a subsequent report to council, and it was decided at that point in time to hold off any enforcement issues until December 31st, 2018. So that was case number one. In November, we had a second delegation to council, and we had some really good discussion on that as well, where another case of a sign being installed without a permit. In that particular case, it was decided that the sign in question remain erected until council review the current sign bylaw. Hence today. So the point of today is really to open discussion, and I'm hoping at the very end of it, maybe we can hear what your suggestions are, what your questions are, and make a decision of whether this is something that we need to revisit again. Okay? Any questions along the way? Please feel free to ask me. Yes.
Out on Highway 27, he came here, he's a power sports guy. He wanted, we told him to take it down, then we gave him a break on it. Whatever happened to that? Did that sign end up coming down?
That sign is
He's
still
got
there.
a last name there the size of my kitchen table, I can't pronounce it, but.
Yeah, that sign is still there today. And there was a little bit of, it was supposed to be down December 31st, 2018.
Yeah.
However, with the second delegation that came in, there was some question. We did it on the one. It's basically, we have to do it on the other as well. So we're holding off enforcement actions until we kind of know whether this bylaw is going to stay as is, or
Okay.
if we are going to be revising it.
All right, thank you.
Okay.
All right, go ahead.
And we're going to actually talk a bit more about that particular case as well. Okay. The training session is broken up into 5 different sections. We're going to go over why do we need to regulate signs, the history of a township's sign bylaw. We're going to talk about sign bylaw 2018, and this is where it's going to be the bylaw 101s. We're going to be putting the sign bylaw into practice, so we'll take a look at a couple of the examples we've had, and then we're going to ask the question, is there anything we really need to change on it? However, I'm sure we're going to have lots of questions along the way. So, signs. Anyone know where this is? New York City, Times Square. And I'm going to show you the tale of two worlds here. New York City has probably one of the most stringent sign regulations in the world. If you want to put a sign up, you have to apply for a permit, and it can only be installed by one of 40 approved contractors out there, specifically for signs. In contrast, we go over to another part of the world, Bangkok, Thailand, where the rules are not as stringent. I can tell you that they have cleaned this up a bit, not by personal experience, but from further readings on this. If you look in this particular case, you have several signs which are located along the street. And if you go further down into the actual boulevard here, the sign projections which are coming out of the building are maybe skimming the tops of vehicles by a couple of inches. From my building standpoint, these really scare me as well, as I see them here. However, we don't have snow in Bangkok, Thailand, but we are in spring water. Okay? What we are typically seeing is a lot more subtle cases. Advertising companies who put signs up directly on signboards or on township signs, plastic signs on the corner of properties. I did a new roof. Can I put my sign up? Sure, go put it right there. We have individuals who are putting signs up to advertise their businesses as well. And of course, the ever popular billboard signs we see on Highway 400 or 11 on a daily basis, or 26. So I'm going to take you back a couple of years in 2014. In 2014, we took a really proactive approach, and we used the opportunity because we did have 2 enforcement officers with us during that summer. And this picture shows Jeff and Rachel, who were with us for a couple of months. And they were tasked, or one of the things that they were tasked with is to clean up the sign clutter. And he did a really good job at this. They managed to actually locate about 165 illegal signs. At the end of it all, they assessed over $5,000 worth of fines, including one that was in $120 in fines. So that was a very proactive approach, and it really did clean up the township quite significantly. So why do we have a sign bylaw? Sign bylaws are looked at a lot of different ways. They regulate where the signs can be located, and I would also say there's a safety aspect of it as well. Maybe a sign at the corner lot that is at the junction of an intersection should have a certain line of sight issue that we should contend with, as well as a clearance to our boulevards to ensure that a snowplow is not going to be hitting it when it's going through. There's also the aspect of trying to maintain a clear and positive image of the township. And also, it provides standards as well. We realize that there are signs in our common daily lives, whether that be real estate signs, which we know this advertises it's a property for sale. We want to recognize it. We want to help them out, not hinder, and provide some leeway along the lines of what they're permitted to have and for how long. So the history of a sign bylaw. Prior to 2009, we actually did not have a sign bylaw. Then the discussion came, maybe we should. And actually, it was one of the billboard signs I do know of that probably caused a little bit of a stir with some residents. And it wasn't shortly after that where a petition was presented to council at the time, and we did enact bylaw 2009-055. That was put in place, it was used. Around 2015, the topic of maybe we should revisit that came up, and we did. And we had some discussions in council. February, there was a report, really good discussions on that particular report to council. And finally, March 7th, it was adopted. A slightly revised bylaw than what we had, slightly, and we'll kind of go through that. And the other bit, we use it as an opportunity to take a part of the zoning bylaw and actually move it over to our signed bylaw. And that was part of a good housekeeping practice, so that we can use one document in order to enforce, rather than try to go to two separate documents for that purpose. So what changed in 2013? A few minor changes. Temporary, we had fees that increased, obviously, just a little bit. We had a couple of new definitions that we brought on, and part of that was part of the discussion we had in February of 2018. We had farm and vegetable markets that are now defined, garage sales, which was defined. Highway is incorrect, it was always there, but we did have to bring in a new definition for community groups as well. Home industry, we moved from zoning to the bylaw, as well as home occupation, and we had the term not-for-profit. We also had a definition for temporary, 30 days. And there was some subtle setback modifications we did with the setbacks from 3 meters. Now we permit it 1 meter from a highway. And occupational signs, again, we moved it over, and we made a subtle change on that one as well. So previous to this, if you had a home occupation, so this is actually illustrating a home occupation on Finley Mill Road. Some of you may know it. And previous to this, the only place you were actually allowed to have a sign was up against the building. It probably would have worked in this particular case. However, if you had a property that was set back 300 feet, 500 feet from the roadway, a small 1.2 meter sign is not going to do very good. It's not going to do its purpose. So it permitted an opportunity to move it up closer to the road, so at least it's visible to the public. So this is the 101s of the sign bylaw. So sign bylaw, when you look at it, typical makeup of what you would typically see in a township bylaw. Definitions. We'll go through some of these definitions, actually show you some visual examples as well. A-frames and sandwich boards, I'll have some examples. But advertising devices. An advertising device is basically a sign in another terminology. And it includes signs, flags, banners, pennants, lights, or any other intended devices used for advertising purposes. Community groups. And again, this is one of the items of discussions that we had. And that was added primarily for the Elmville BIA to allow an opportunity for maybe just let's expand a little bit more. It doesn't have to be not-for-profit organizations that have some leeway in terms of what they can do, but it understands that there's a greater part of the community that may need signs to be utilized as part of their community groups. Advertising devices, so some examples here. A-frame signs, so the A-frame sign that you see there advertising Indian cuisine, keep a mental note of that one there as well. Lawn signs, very common. Teardrop signs, we start seeing quite a bit of these now. The mobile signs, another one, make a mental note in terms of where that sign is in relation to the highway. I may ask for your opinions on that. And as well as the billboard signs. So see, these are just some examples of advertising devices or signs in general. Home occupations. So the terminology here is basically what you would find in the zoning bylaw. Home industry is industries which are going to be secondary in nature to the primary use of an agricultural property, and it'll be a repair shop, a farm implement facility, machine repair garage, something of a more of industrial or commercial nature, and it's there to augment or to help out with the agricultural community. Home occupation, your home businesses basically. That's what it's for. And again, it's got to be secondary to the primary use of the property, which is going to be residential in this particular case. So this is the definition. Again, it comes from the zoning bylaw as well, word for word. Section 2, we start dealing with the regulations. So very simple, you cannot erect, display, repair, alter any sign without a permit. Location-wise, we state it's got to be at least 1 meter away from the highway. And highway is a defined term. If you do have a temporary sign, we do permit them for garage sales, real estate homes, for real estate open houses, for instance. And we do allow it so that it's maybe not on the property that's actually for sale, but you can have directional signs, and it's up for 3 days without a permit. No problem there. You can't affix signs to any tree or utility pole. And I believe, Brittany, a lot of what was Brittany was, or you can confirm, back in 2014, there was quite a bit that we took away from trees and sign poles, that particular case. And you can't have a sign that interfere with traffic, emergency access, line of sight, or a normal flow of pedestrian or vehicle traffic. Case in point, going back to that example I had with the Indian restaurant, Indian cuisine restaurant, maybe not the best place if someone's coming up to it with a wheelchair. If I found that, I would probably ask the person to move it just out over a few more feet from where it is. Wording or images cannot be offenses or inappropriate. If you do have a home business, you are only advertising the business that is on the property. That's one of the conditions as well. Home-based businesses, if you are going to have a sign-wise, it's limited to 1.2 meters. What's 1.2 meters? It's a real estate sign, basically. It's equivalent size as that. And it's there, but sometimes you just do have to put it on paper. If you do install a sign on private property, make sure you got the owner's permission, obviously, to do it. And obviously, if you have a sign on a township property, we can remove it if you don't have our permission as well. So enforcement and penalty. One of the other things that came up in their discussion back in November was enforcement. And you probably heard us mention this numerous times, but the philosophy when it comes down to enforcement is you inform, you educate, and you enforce as a last case resort. If needed to enforce, that is usually, in terms of time it takes, you always want to get enforcement through, what was the terminology I was using there before? Conformance, yes. You want to, compliance through cooperation is always the best approach we have. And we do believe in that philosophy, and we do try to do that. If we have to enforce, it's usually as a last case resort. You leave us no choice in the matter. Fees, we only have two simple fees on it. $50 for temporary, $75, and we do have some leeway in terms of not charging fees for vegetable markets, as well as we don't double dip as well for if you come in with a sign that actually needs a building permit, we're not going to also charge you for a sign permit as well. And that's what the provision is in there for as well. And the clerk does have some leeway in enforcing or utilizing that as well. Other exemptions in section 5, federal, provincial, municipal signs are exempt, as are directional signs, traffic signs, go this way, go that way, whatever the case is. Real estate signs permitted, but it has to be on the property that's for sale. You cannot advertise your buddy Joe down the road who's advertising his property for sale. It's got to be Mr. Joe's property only that is able to have a sign up saying it's for sale. Signs, and if you are an agricultural property, you can have a sign, no problem. However, you have to keep 1 meter away from it if you're selling goods or services which are on that property and producing on that property. Election signs are not included in our sign bylaw. That is under a separate bylaw altogether. Now, administration-wise, it is administered by the clerk's office, and enforcement is done by the municipal law enforcement officer, roads department, and building officials. And there is a provision in there where it says if we have a situation where an employee of a township deems a sign as being dangerous or at risk to the public, we can remove it. And that provision is in there for roads department, for example. And if they see there's a sign in the way of a snowplow, they're probably going to want to move that. That allows the permission for that opportunity to remove that sign. And section 7 and 8 are really the administrative provisions where it repeals our previous bylaw, as well as a simple provision where it says if one of the parts of the bylaw is deemed to be not conformance with the court, then the rest of it stays on its own merit. And we do have some provisions in our bylaw for Part 1 tickets. And Part 1 ticket is essentially no different than a speeding ticket where you have set fines. Here is your fine. The individual has the opportunity to appeal it through the court system, or just pay the set fine that is on that ticket. The other opportunity for us is to do what's called a Part 3 ticket, and that involves going to a court and you're talking with a justice of the peace, and that justice is really going to be setting the fine if deemed to be a guilty charge on the part of the infractor. So putting the sign bylaw into practice, and this is where we're going to get into examples. So the first example here, and I just want to say they did things right, okay, right from the start. Some of you may know the building. So they had an existing sign, which is shown right at the corner, close to the street there, or sidewalk, I should say. And fantastic. They came in here with a permit. They wanted to put an LED sign up, apply for the permit, and the process that we have here is that permits get circulated to the various departments in the township. And the departments in the township have an opportunity to provide opinion. Usually, I'll give you an example. Planning may have an opinion. This property is zoned for institutional use, church, no problem with the sign. Public Works may look at along the lines of a snowplow issue. If we are clearing the snow on that sidewalk, is the snowplow going to be hitting it? And building looking along the lines of a sign and on a safety aspect of it. Bylaw will be looking as a more generality of the actual application of it, and on and on and on. And if there is an issue, then we will let the individual know. In this particular case, all was great. And the sign was installed, all's good. So, some other examples here. In this particular case, we receive a complaint regarding a sign off a major roadway. Bylaw investigates, two-sided advertising sign. It's advertising a car dealer, which is not actually in the township, but in another municipality. Size of the actual sign is about 4 foot by 8 foot on each side, just to give some relevance to it, or idea of the size of it. Located on a residential property, on the backside of a residential property, and it's facing a highway, MTO Road, highway, or Bayfield Street, or Highway 26. No sign permit on file. And the sign was advertising, it was an existing sign, however, it was refaced as well. That's the other caveat on this one here. So when we investigate it, we always take a look and see, is there any provisions there which would permit the sign? And we kind of go do our check. And we had a couple of issues with what we saw here. Did they have a permit? No. If they even replace a sign facing of it, they would require a permit as well. So we had a bit of an issue with compliance on that point there. Then we look, okay, would this have been permitted if it was an advertising sign? Well, it was an advertising sign for at one point in time, but it's not anymore. And if it was, it's well exceeded the length of time where it should have been there. Now, it says 212, but there's actually another provision which makes more sense. And the other provision that makes more sense is a provision there with home occupation. And it was not advertising a home occupation in this particular case either. Even if it did, we still had a size issue with this as well. Other problem with this one is the fact of, even though it required a permit from the township, it also required a permit from the MTO as well. So we had a bit of an issue there. And then we take a look at possible exemptions, and we didn't have any exemptions in this one here as well. So we did have some issues in terms of enforcement matter. Second issue, or third example I have here, is another sign. In this particular case, it was a two-sided advertising sign. One was advertising a realtor company. The other side was advertising a moving company. This has changed slightly since this was brought forth. The property is not listed for sale, as a key point. It's located on a private property and zoned agricultural. No sign permit on file. And they did have a permit from the county for the sign, but not from the township. Looking into the county's provisions, they went through the process, they obtained the permit. However, the county even has a provision saying that even though you do get a permit from the county, you still have to review it with the township as well. And it's a standard approach, and actually the MTO has a very similar type of approach as well. We did the exact same thing, and we're getting a lot of no's on this one here as well. Did they have a permit? Definitely not. Although they had one from the county, they did not have one from the township. Was it a real estate sign or a temporary sign? Maybe. Could we look at it that way? Well, the property that it was advertising, it was just advertising for the realtor of in general, not really the property that was for sale. And there was also another part of the sign that was advertising a moving company. So we had a couple of issues over here. So we can't even use 2.3 in that particular case. And 212 is there as well. And again, 216, same thing, where we looked at home occupation. And the property was not even zoned for permitting a use that would establish using it for commercial use as well, that it was advertising. The moving company wasn't there as well. If the moving company was there, yeah, you would have been permitted to have that sign there. But that was not the case in this particular situation. Those are just a couple of brief examples and a very brief overview of the sign bylaw. We just want to start the discussion here, knowing that. So my next question is there a need to change anything? What are your thoughts on this one here? Yep.
Councillor Cabral?
Thanks very much, Mayor Allen. Actually, I was just curious on that last one where jurisdiction for the county roads falls under the county and they issued the permit. Would the person, if they got a permit issued by the county, there's a bit of a conflicting thing here where county tends to supersede what we kind of want to do. Would they have to, maybe there should be something in there that would permit something like that? With respect also, would they have to submit for 2 permits and pay twice as well, just because they happen to live on a county road? So I guess I'm just thinking along those lines on that one.
Director?
Through the mayor, yes, they would have to submit twice. In this particular case, for that example, what really happened is they actually came to us first. Were denied based on the fact that the property was not zoned to permit those signs to be on that property. And there's a little bit more to happen, but it went back and they went to the county, got the county's okay, but they would actually need both permits. No different than the MTO situation where MTO would give clearance and then they would require clearance from the township as well. So there is some situations where it's going to be 2 permits that are required. And the county's provisions basically say if you're putting a sign, it's got any sign that's within 400 meters of a county road, you have to get clearance from them as part of it as well. So yes, you need 2 sign permits basically from both.
Just further to that, when they go to the county and do an application, I would presume the application would make reference, have you obtained something or applied at the municipality, does it?
Mayor Allen, the application, I haven't seen the application, but I know what comes back from the county, it does state that, where it has to be, and knowing the individuals who at the county, they do make it a point of letting those individuals know as well.
Councillor Hannah?
Thank you. Nick, can we go to slide 16, please? See, I didn't ask you what time it was. On the bottom of slide 16, the reason I'm asking, it says, cannot place a sign where it will interfere with traffic. In Midhurst, I'm sure it's a lot of places you see them as you're driving through, but in Midhurst, there's a few of these signs that people put out that say, slow down, and they look like a little child with a hand up or something like that. Are they permitted or not permitted, given what it says at the bottom of 16?
Director?
Thank you, Mayor Allen. I'm just trying to, and through to Councillor Hannah, just trying to think of what they look like. And these are the little men, I believe, or kids that are playing and whatnot. If there was an enforcement issue and someone let us know, I think we will take a look at it. If we did look at it, I think we would have to look along the lines of what the intent of it is, where it's located to see if there is an issue on it. I will also ask maybe my person here on my right here to maybe provide some assistance if you have experience with that.
We haven't experienced anything with that, but we would definitely have to take a look into it and kind of see where it is, the setbacks, where it is on the road, and determine if it would be an issue for the traffic flow or even for pedestrians walking. Again, it's where the location is. And then we have had other situations where people have put signs out, and then we've actually sent it off to the Public Works Department to go take a look, and we've actually installed proper signs for that. So that's also another approach that we can take.
Follow up?
Go on.
Generally, they're put right up by the edge of the pavement because the intent is to get the traffic to slow down. And I'm just wondering, going forward, before we get criticism, maybe something you might want to word to permit that. And my second point is that if we're going to be restricting people putting sign up, I believe it could increase the number of these abandoned trailers and parked vans you see just off of the road on private property, advertising, plumbing, and there's a big one on Bayfield Street the car dealer has up there, and it's been there for years. It's a wagon. So we may be creating more of that, and I don't see anything in this bylaw that might address that stuff.
Director?
Thank you, Mayor Allen. Over to Councillor Hannah. The mobile units or units with wheels are a very contentious issue. You can look at them along the lines of a vehicle, and if they are, then they got wheels on it. If they are licensed, we have to almost let it go type of thing. And we do realize that there are maybe a few that are pushing the limits and using the definition of what is a vehicle and extending that. And I would say right now, we will look at each one in the individual case. There is no provisions that really directly addresses this. And without telling them that they can do it, there is definitely a little bit of a gray area when it comes down to that, which is not really identified in this bylaw when it comes down to this.
Councillor Moore?
Thank you, Mayor Allen. So a number of these signs happen to be in Ward 4. And I know the gentleman on Bayfield Street, one of his, and logical concern or complaint really is that he's in the middle of other commercial properties on Bayfield Street. So from looking at it overall, it doesn't look out of place because he's in the middle of all this commercial property. So it doesn't look, sort of that it shouldn't be there. I just wonder, what is the process now for people who have signs up and don't fit your bylaw? And secondly, the signs that I see too that are old, that have been let go, they're dilapidated, they're just sort of hanging on. What are we doing about those? And particularly, there's a couple of farm market ones that are not on farm property, but on neighbors' properties, for instance, that they're doing a favor. But they're old and crappy looking. Just wondering what we're going to do about those two.
Director?
I'm just through Mayor Allen to Councillor Moore. So the farm properties, and I'm just trying to think here along the lines of using clean yards, clean and safe yards, and we can't for agricultural purposes. So there's no provision under that other bylaw which we could utilize. We can look at we don't even have a property standards bylaw, so we really can't use the property standards bylaw either. If it was a safety matter, then I would say we could look at it. If there was signs, and I can think of one particular case where I did have a sign or something that was falling, and we looked at it along the lines of a safety matter for pedestrians to make sure that was not of an issue. But if it's in the middle of fields with no provisions or property standards or clean yards implications with agricultural properties, we don't have a lot of mechanisms there on that particular case. Okay.
Follow on?
Thank you. And then to my first question about, it's Mr. Bosiowski's property that big sign is on. How do you feel then about it fitting in with the landscape of the rest of Bayfield Street?
Yeah. And unfortunately, Mayor Allen, through Councillor Moore, there is, again, no provision in there in our bylaw right now that allows an appeal mechanism. So to look at conditions where it allows some flexibility based on the conditions of the in situ situation there. That one maybe is a little more unique than other situations, and I'm sure there are several other locations out there. But there is no appeal mechanisms, and that's probably one of the reasons why we do have delegations that are coming to council, is because there is no appeal mechanism currently in our bylaw.
Councillor Cabell?
Thank you, Mayor Ellen. This actually goes back to Councillor Hannah's comment, but it does come to mind that often there are considerations within the township, not just ours, other townships as well, where people want to make statements for specific organizations. Right now, what we're starting to see in the north end is people are beginning to mobilize with respect to the Waverly Uplands and Save Our Water, and those signs are popping up. I can think back to when we had the Site 41 issue, and there were signs all over the place. I just am thinking that these are people who are making what one might consider freedom of speech statements, and they're using their own personal property to do some. I'm wondering if there might be some way to permit some flexibility for that, because it doesn't happen all the time, but right now there probably will be more and more of those signs. And I'm just kind of wondering how, or if there's a way to mitigate that, where we're not ticking people off, because I'd rather them be mad at the aggregate company than Springwater Township. And I understand why they're doing it. And I could see maybe the similar thing happening over on Horseshoe Valley as that continues to make its way through the LPAT process.
Director?
Thank you, Mayor. Over to Councillor Cabral. The provisions under the bylaw are very black and white, unfortunately. The only thing I would like to comment on is the fact that we are dealing with sign enforcement on a complaint basis. So in the case of going back to Councillor Hannah with his slow down signs, or in the case of your case where signs in the north may be advertising an opinion, then if those came up, we would review it based on the complaint that was presented to us. We would maybe look at along the lines of, is this temporary in nature? And I think there maybe could be a case in both positions where they could be temporary in nature. Doesn't meet the 30-day mark along the lines of which is established in the township bylaw. Maybe or maybe not. But it could be in, it could be out as well. So, but right now it's very black and white. There would be no provision that would allow some flexibility on that, unless you went into a community group, which could permit it, but there really is no flexibility, I would say, right now, the way it's written, to permit that.
Sullivan?
Yeah, thank you. Actually, that might have, I think it's one particular community group, not within Springwater Township, that is making the signs available for, nominal fee. I just see the potential for a lot of very disgruntled residents. I'm just wondering if there's a way that if we do review that there's some mechanism in there for these specific types of situations where it's not one or two people just, selling wares, but it's more of a community focus on a community issue, that these people feel strong enough that they're putting the signs up on their lawns. Just like I say, I don't know how you would do it, but as you've said, it's black and white. It's not for a home occupation. It's not to sell the house. So 3 days isn't going to cut it for a garage sale. And even the 30-day one, this may go on for months and months, maybe even a year, with these people wanting to keep these signs on their front lawns. So, and I understand you're saying it's an enforcement issue, but at the same time, if someone does complain about it, that one person is going to be talking to other residents who have a similar sign, or they're simply going to refuse to take it down. So I don't know how we'd want to try and manage that, but I wish there was a way to do it.
Mayor Allen, to Councillor Cabral. I think that is definitely something that staff can look into, and if the will of council is that, you know, there are some issues here, and we want to kind of move forward with revising or looking at it, by all means, we're going to take your comments into advisement and look into that in further detail. The bylaw itself was very simple along the lines of maybe not realizing all the potential issues that could be occurring. And I think with anything, as we know as ourselves in our careers, things need to grow or expand on or identify further. So we can absolutely look into that if that is the will of council.
Before going back to Councillor Hannah, remind us, sign complaints, how have they been going? I know you have them in your bylaw reports, but just generally over the last year, let's say, what's been the trend of sign complaints?
My apologies, Mayor Allen. We don't have that information in front of us. We can definitely look into it and get back to you and see exactly how many are specifically coming through to our desk.
And I guess the type, you know, what is the complaints, or try to categorize it, get a flavor for what we're hearing. Councillor Hannah?
Thank you, Mayor. Nick, the Midhurst Pavilion, they've rented out sign space to put signs up in the pavilion as fundraisers. I'm positive they haven't got any permits for any of those signs. They were installed by the Works Department or Parks and Rec installed them in the pavilion, and they're hanging on the wall or from the ceiling in there. Does that affect this bylaw, affect them at all?
Director, and that's common for different communities in Hillsdale and Minising, down in Grenfell.
To Councillor Hannah, my thoughts on that is it's a township building at the end of the day. So I don't know how much bite this would really have. And there is provisions where it does make mention regarding the township aspects of it. And I did go through it in my presentation briefly, but I believe it's a township building. It won't be identified, and I don't see much of an issue with that personally as part of it. No different than the arena in Elmville.
Councillor Moore touched on grandfathering, and that has been brought up before us before. What are your thoughts with respect to that?
Mayor Allen, so when it comes down to grandfathering, we have to be cognizant that the bylaw came into place in 2009. If an existing sign was in place prior to 2009, I don't know how one could kind of approach along the lines and physically identify that it has been there. How we do that, I don't know if that's through Google Earth or Street Views or whatever the case is, but if you see something that's there existing, I don't know how you can apply an existing sign bylaw in there. However, the caveat on that is there is a provision in our bylaw where it says there was an opportunity for the individual to obtain a permit prior to if it was illegally established. The problem we're going to have is I don't know how we would actually identify whether a sign was legally established or not as part of our current database and our systems. And that's just basically based on my observation and historic viewpoint along the lines of trying to identify whether permits were allowed for or if permission was granted on existing signs.
Okay, there don't seem to be any other questions, so what do you recommend our next steps should be?
My suggestion would be if there was an opinion, I think that there is several items here that we have to look at, then perhaps one of two things can be done. One would be I can bring a report to council, maybe just identifying that we've had this communication, that we've had this presentation done. There are some key points that we're going to bring forward, and we're going to do some research on it. Maybe identify what the key points are that we are looking at, and maybe we'll start the process on reviewing the sign bylaw as part of our process. I think that's probably the most what makes the most amount of sense based on what I'm hearing here today.
Councillor Moore?
Thank you, Mayor Allen. I wanted to ask a question about enforcement, because the challenge that I've seen over the past year, we did have one sign complaint come forward. It was sort of a random complaint when an employee drove by, saw a sign going up, and voiced a concern about it. That sign happened to be across the road, which was also not in compliance, but no complaint was made about that sign. So we've got neighbors that are fighting over, my sign's okay, but yours isn't, and they're virtually the same. So I really want to know what you're going to do about the enforcement piece when faced with situations like that.
Director?
Thank you, Mayor Allen. Over to Councillor Moore. Welcome to my world. This is, usually we find one enforcement issue ends up becoming 2 or 3 issues because that exactly is what happens. So, and weekly. If that individual identified and provided a complaint, then we would review that as well. So that would be another complaint that we're reviewing as well. We are driven by complaint basis as opposed to a proactive review. So we have to also take that in consideration.
Follow on?
Thank you. So are you saying then that if that second sign had no complaint filed, you would not see it? Or how would you handle that?
Director?
I would look at it 2 different ways. If I actually saw it under construction, I think I would have to say something on that one there. With that being said, I'll give you a little bit of example, and you can do the count on your way into the Township of Springwater. There are 37 signs between the Township of Springwater border from the city of Barrie over to Highway 26 to the corner of 26 and 27, the split there, on the right-hand side going northbound only. So, and it is a difficult situation. And if we were kind of to take a look at every single one and then go back into the history books and say, okay, do we have a permit for it? We just don't have the workforce to undertake that. And that's why we have to look along the lines of, if there's a complaint on it, we'll spend the time looking at that particular issue.
Councillor Hannah?
Thank you. I'll make it quick. Nick, quite often you see people have got their house painted, or they're getting a garage door fixed, or they've had work done on their house, and they have the contractor sign in front of their house, and it's not there just for the time it's happening. It stays out there for quite a while. Does that fall into this bylaw?
Director?
Yes, it does.
And I believe it said for 3 days they could go up?
So, Councillor, or Mayor Allen, the actual, nothing. They would not be permitted. They would have to come in for a sign permit for that. The 3 days would only be for a garage sale or for a real estate open house sign. That would be the only allowances for that particular case there, right now under the bylaw.
So under the existing bylaw, if somebody's going to sell their house, they only have 3 days to put a sign up without getting a sign permit?
Correction on that. So if it was you have a real estate agent who's selling a sign, it is understood that that real estate person can have a sign up on that property while it is for sale indefinitely. However, if you have an open house and you're trying to direct traffic towards that open house and need to put it at the corner of a roadway, you are permitted to have that sign on the corner of the roadway directing the traffic for up to 3 days, or on another person's property. That's the difference on it. A real estate sign, you can have it on your property while it's for sale.
So both the owner can if they're selling their own house, and the real estate agent can if they're acting for the owner. Is that correct?
Correct.
Okay, all right. So there's a recommendation here that the presentation regarding the sign bylaw training be received, and that a further report regarding a review of the sign bylaw be provided with recommendations at a future meeting. Can I have a mover and a seconder for that? Deputy Mayor Coghlan, Councillor Cabral. All those in favor? Carried. Can I have a mover and a seconder to confer and adopt the proceedings, please? Councillor Cabral, Deputy Mayor Coghlan. That bylaw 2019-087 to confirm and adopt the proceedings of the council at the special meeting held November 6, 19, listed herein, be signed and sealed by the mayor and clerk. All those in favor? Carried. And an adjournment, please. Councillor Chapman, Councillor Moore, that the special meeting of the Township of Springwater does now adjourn at 5:49 PM to meet again at regular meeting on November 6, 2019, 6:30 PM in the council chambers, Admin Center, Minnesing. All those in favor? Carried. Thank you. Thank you for the presentation.